Ooh, that's got a kick to it. Holy buckets.
It just tastes like pickles. I don't like it.
That is so hot.
Welcome back to Hot AF. Happy to see you again. I'm joined today by Nicole Weinand, our resident subrogation expert. So today we're going to be talking about subrogation, a little bit about hot sauce, and some workers' compensation.
Looking forward to it, Scott.
Ready to dig in?
Happy to be here, yes.
All right. Well, first off, we're going to do a truffle hot sauce from Truff. It's a jalapeno lime black truffle hot sauce.
Okay.
Lots of flavor in this one. Not super spicy, but it's delicious. And I'm going to read a question while you are trying this.
Okay.
So start your thinking. When you're evaluating a workers' comp file for subrogation potential, if it's there, what are some of the top 3 facts that you want to immediately know about, even before you, for example, requesting any records in the case?
So 3 things that I want to know in a subrogation potential matter is what happened, obviously, what caused the injury, whose property was involved, if any, because that tells me who might potentially be liable for that injury. So were they in a car? Were they using a piece of equipment? Were they actually on somebody's property? I would want to know whose property that is. And then how is that party related to the employer? Because there are certain relationships where either you can't go after them or there's some contractual provision or a waiver of subrogation provision. So I would want to know how they're related to our employer.
And it could be more than one other party too, correct? Like
Absolutely.
You could have 3 or 4 or however many, especially on a construction site, for example.
Correct. So on a construction site, the subcontractor who is at fault for whatever danger or defect or hazard on the work site that caused the injury, and then whoever hired them or brought them on. So the contractor above them, certainly the general contractor on up the line.
Okay. Our second one here is a Thai green chili sauce, obviously from Thailand. It's extremely good, lots of flavor. Not a lot of heat, but I can promise you it's very good on ramen. I have not had it on chicken yet, but what is the single most common mistake that you see could potentially reduce the subrogation recovery or cause a problem to prevent the recovery?
Sorry, I need some milk. Hold on here. Okay, so the thing I see that is most detrimental, thank you, to a subrogation recovery is just not acting quickly or failing to act on a notice. So many times I will see where the employee's attorney in the third party case has sent a letter saying, I'm going to engage in settlement negotiations with the other side. That just gets put into a file. And then the reason it comes to my attention is because they find out that the employee settled around them on a neg, and they're like, well, what do I do? And at that point, you're kind of stuck. The purpose of that letter is to let you know that I might just settle around you, and so you should start engaging in your own settlement negotiations.
Is there a timeline that you have to comply with to do that, to provide the notice?
No, the biggest timeline you have to be aware of is the statute of limitations. So that's another problem. If you aren't regularly monitoring the case or don't have a tickler system or some kind of reminder or calendar where that statute of limitations date falls.
Okay.
Once the statute of limitations runs, you don't have a claim, period.
Period. Yeah. Okay. Our third one here, I'm a known pickle hater, but this is a hot sauce from Ass Kickin' in Arizona that former guest Natalie Lund brought back recently for us to use, and it's a pickle hot sauce. I'm going to leave it at that.
I'm excited about the pickle.
How do you coordinate a workers' compensation claim in a third-party case so that the recovery or the lien is not compromised by the timing of the settlement or settlement language in the in the work comp aspect, or vice versa.
So, ooh, that's got a kick to it. Holy buckets.
It just tastes like pickles. I don't like it.
Oh, that's the best part about it, but it has a kick to it. Okay, so it is always better from the subrogation potential to settle the work comp case before the third party case gets resolved.
Okay.
That way you know how much your lien is, and you can, at that time whether you're on the hook for future treatment. Do you care about the future credit or not? That's sometimes a sticking point. If there is going to be future credit or future treatment, then you want to be able to address that piece in your settlement tactic of the third party claim, because it might be better to do it on a reverse neg
Okay.
instead of running through the formula.
Got it. So that's something that you deal with on the liability side, not the work comp side. That language.
Once the work comp case is settled, then you can evaluate what the best way to settle the subrogation claim would be. As far as the work comp settlement, the language just really needs to be clear that you're preserving your recovery rights, subrogation and indemnity against any at-fault party, and that the employee is not going to jeopardize those rights and will keep you in the loop.
Okay.
Essentially.
So kind of you'll cooperate with any claim that might be made in terms of subrogation from the employee's perspective.
Right.
We'd want to make sure they're complying with it.
Yes.
Or cooperating.
And they're not going to just go off and leave your interests behind and deal with their own interests.
Got it.
Yep.
Our fourth one here is one that I recently picked up from Trader Joe's, and it caught my eye because it's a sweet potato habanero hot sauce. It's extremely interesting. There's hints of cinnamon and allspice in it. It's very interesting. Very good. It's got some heat to it, though. I will warn you.
I'm still heated.
Is there a quick test for deciding whether to intervene in an employee's third party action versus kind of staying in the background and waiting for things to happen?
So, intervention as a right requires that the employee's attorney is not properly representing your interest as well. So when the employee's attorney brings a lawsuit on behalf of their, oh my goodness, that is so hot.
Just wait for it.
Oh yeah, it's there.
We got more in store for you.
Yeah, I see that. The employee's attorney has to, when they sue out a case, they are also suing out your subrogation interest. So they are combined. The only way you can intervene is if that interest is not properly being pursued or prosecuted by the employee's attorney. So for instance, if you get a copy of the complaint and nowhere in the complaint are they saying that medical bills were incurred, they haven't made a claim for your medical bills, or they haven't made a claim for your wage loss that you've paid, then you need to start stepping in and at least either, is that a mistake? Did you mean to exclude that? Can we get it amended? And if truly they just are not protecting the work comp interest, then you need to intervene because they're not going to do it for you.
And what's that process look like? What do you have to do?
Sure. It's actually very easy. You serve a notice and a complaint and intervention. And the other parties have, I believe it's 30 days to object to the intervention. There are some elements that are set out in the rule that applies. It's Rule 24 of the Civil Rules of Procedure. And you just have to satisfy those 4 elements. Typically, there's no objection because everyone understands that the work comp carrier and employer have a right to intervene.
Right.
And the dispute will always be whether the employee's attorney is going to, protect that right.
Protect it. Okay.
Yeah. Because the defendant doesn't want two plaintiffs pointing the finger at them. It makes their job harder.
Makes sense.
Yep.
Our last one here is another special selection from Natalie Lund that she picked up in Arizona. It's called Habanero Hot Sauce from Hell, Devil's Revenge.
Gosh.
Now, it's habanero based, but what they don't tell you on the front of the bottle is that they also go ahead and take some capsaicin extract from peppers, which capsaicin is the pepper, the chemical in peppers that makes them hot. And they added some of that. Now, the extract that they added is 1,000,000 Scoville heat units. Jalapeno is typically somewhere in the range of 200 to 300,000 Scoville heat units. So this is going to be a real barn burner. So with that in mind, in 1 minute, can you walk through the practical workflow from the time an injury happens to the time the subrogation check clears? Who does what kind of and when?
Okay. So the very first thing is on the first report of injury, or I believe that's the first pleading that starts the work comp matter, right? Make sure that you have the right employer on there. There are so many creative ways to structure business entities to put liabilities in different places. And a lot of times the employee's attorney will just capture the parent company or a sister company and not actually name the employer company. That's really important in the third party action because the statute is written for the employer. And if you don't actually have the employer, that can cause problems.
And you and I were talking about this the other day with the name thing, where
Yes.
if they have a doing business as name, that's not the name that you have to use, correct? It's the name of the legal entity that's, so it'd be like Scott doing business as Scott Ferris.
Yes.
If the legal entity was actually Scott and they're just doing business as Scott Ferris, you have to name Scott, not. I don't know if I explained that correctly, but
So you need the business entity that is registered with the Secretary of State as either a corporation or a limited liability company or a sole proprietorship. The assumed name is the doing business as.
Right.
That's not an entity. It's just a name. It's just an assumed name for some legal entity that can actually answer to a lawsuit.
So it's always important to make sure that you're not filing against the assumed name. You want to make sure that it's the legal name.
Right. And you want to make sure that if there's multiple companies in a business, so for instance, they will have a company set up to own the building. They will have a different company that operates the business inside the building, and then a different company that employs the person that does the maintenance who actually got hurt. So you want to get the employer instead of the building owner or the operational owner.
Would you add all three in that situation, though?
As the employer?
No, just as defendants in the case.
Depends on what the basis of the claim is.
Okay.
So if the operations are at fault, somebody negligently does their job, then you would sue the operation company. If it's the premises, so slip and fall is the easiest example there, then you would sue the building owner and not the operations, unless they were responsible for the maintenance. So if they are the ones that mop the floor,
they would be the ones that you'd want to go after. Okay.
Exactly. So I got caught up in step one and I'm already into it. Okay. So you also want to identify your target defendants. So we just kind of went through that exercise in a slip and fall situation where it's a building and operations. Car accident, you want to make sure you have the owner and the driver.
Because they don't, not necessarily the same entity.
Yes. And we talked about like the construction example is another way you want to make sure you have all your target defendants. Once you figure out who your defendants are, you want to make sure that you get all the contracts between your employer and the defendants to know what duties were owed between them. The employer can get, attorney's fees or things from contracts that they can't necessarily get from the statute, like the work comp recovery statute.
Okay.
So it's important to get those contracts. Obviously, any accident reports about the incident, and then any other documents that exist either about the incident or about the relationship between the parties.
Okay. Like the employment relationship or
the
whatever
relationship
it is
between the employer and whoever you want to sue, and then also the insurance company and whoever you want to sue. because if the person that's at fault is also insured by the same insurance company, there's a statute in Minnesota that you can't subrogate against them. So
Okay.
you need to know that early, because otherwise you can go down a long road and spend a bunch of money and then not be able to recover anything at the end. So it's good to know who's who and who they're insured by. Then notice letters go not only to the employee's attorney, but also your target defendants. You want to capture their liability policies. It's the liability adjusters that are going to make sure that all the interests are settled, and they will not forget your interests. The employee, as we discussed, can leave you high and dry.
Right.
Yes, you need to put them on notice, but you also need to notify your target defendants so that their liability insurers can be put on notice. And then you really need to be vigilant in following up, because that's goes back to my previous point of not acting quickly. When things are happening, you need to get involved at the right time and make sure that your interest is protected. Then you want to monitor, obviously, whether there's any litigation, what is the status of the litigation, make sure that all the deadlines are being met. And again, the whole time you're evaluating whether the employee's attorney is accurately representing and pursuing your work comp interests.
Got it.
And then you're, if not, looking at an intervention situation. Then once you figure out what's happening, you figure out what type of settlement is the best, like we talked about earlier. Does it make sense to do a global settlement? Does it make sense to do a reverse neg situation? Those are case dependent. And then it's just a matter of getting the releases drafted and signed and payment instructions provided, and then you get a check.
Simple as that.
Simple as that. That's right.
Well, thank you very much for coming by and talking a little bit about subrogation with me.
Appreciate it.
It's been helpful. And if anybody out there has questions about subrogation, please feel free to reach out to Nicole or any of the attorneys here. And we're happy to help point you in the right direction and provide assistance. And if you have any suggested topics for future episodes, please leave your comments. We look forward to that. Don't forget to smash that like button.